Diddy's lawyers just quietly flip their whole defense, and it's a tell. Watch what just happened. Not the headline, not the noise, the actual paperwork. Because somewhere between the press releases and the prison commissary, Sean Combs' lawyers walked into a Los Angeles courtroom, looked at the defense they filed last fall, and quietly rewrote the most important sentence in it. They didn't issue a statement. They didn't tweet. They just edited. And if you know how civil litigation actually works, that little edit is screaming. Because you don't change your story when your story is winning. Real quick before we get into the surgery, tap that subscribe button and ring the bell while you're at it. The Combs legal universe is unfolding in like 4 directions at once right now, and I'm not letting you miss the next domino. Y'all keep me locked in. Let's get into it. The setup fast, so we're all on the same page. Jonathan Hay, Florida-based publicist, music producer, the John Doe behind that civil suit filed in July of 2025, is the man currently knocking on the front door of the Los Angeles District Attorney's office. 2 alleged incidents, one from February 2020 in an LA warehouse storing Notorious B.I.G.'s wardrobe, one from March 2021. LAPD and the LA County Sheriff's Department each ran their own investigation. Both sets of detectives walked their case packages over to Nathan Hochman's office in January. The DA confirmed the review on June 3rd of this year. That's the air the civil case is breathing right now. That's the room Combs' attorneys are filing in. Now watch where their hands move. On April 24th, 2026, Combs' team filed an answer to Hay's amended complaint and dropped a phrase that, if you've been following along, hits you in the gut. From the filing, as obtained by TMZ. The cause of action for false imprisonment fails because plaintiff consented to any alleged false imprisonment which could have occurred, if at all, only while defendants were not present. Read that twice. I'm serious, because it's doing 2 things in one breath that legally shouldn't share a sentence. Hay's manager, and yeah, we've seen the email, hit back with this. Sean Combs scrubbed his original defense to completely wipe out claims of a lawful citizen's arrest, shifting instead to a desperate blanket claim. I believe this pivot is a glaring admission of panic regarding his criminal exposure. Okay, Combs' civil attorney Jonathan Davis, going back to last fall on the broader allegations. Mr. Combs categorically denies as false and defamatory all claims that he sexually abused anyone. He looks forward to vindicating himself in court, not in the media, based on admissible, material evidence, not rank speculation and unsubstantiated allegations. Strong words. Stronger when your filings actually match them. Hay himself, in writing, to the LA Times the day the DA review went public. I have an overwhelming feeling of hope as we are knocking on the door of criminal justice. Knocking on the door. He picked that phrase deliberately. He's not in the building yet, but he's on the porch. And then the DA's office spokesperson, on the record. In the fall of 2025, LAPD and LASD each presented a separate sexual assault investigation for one victim to the LA County District Attorney's office. We are reviewing the case. Bureaucratic, bloodless, and exactly the kind of confirmation prosecutors give right before they make a decision. Wild. Now let me show you why that little legal edit matters. Because in a vacuum, an amended answer is just paperwork. In context, it's a tell. July 2025. Hay files the John Doe suit in Florida. Same month, the New York jury convicts Combs on 2 prostitution-related counts and acquits him on the trafficking and RICO charges. Bad day for the prosecution up north. The civil action lands almost the second the criminal one resolves. Fall 2025. LAPD and LASD detectives are quietly building parallel cases on Hay's allegations. Combs' team files their original answer to Hay's complaint. In that first version, the citizen's arrest theory is sitting right there as an affirmative defense. The argument, in normal English, yeah, we restrained him, but legally, we had the right to. That's a specific kind of swing. Citizen's arrest as a defense to false imprisonment doesn't whisper. It concedes the restraint and tries to justify it. November 2025, the Sheriff's Department publicly confirms the investigation. C.J. Wallace, Biggie's son, files a defamation countersuit against Hay in Florida. The civil universe expands. The criminal universe gets quieter and heavier. January 2026. Both LAPD and LASD walk their case packages into the DA's office. Hochman's prosecutors start reading. April 9th, 2026. 3 federal appellate judges hear Combs's appeal of the New York sentence and reportedly raise questions about whether 4+ years was actually too harsh. Combs's team smells daylight on the existing conviction. April 24th, 2026. 15 days after the appellate panel sounds friendly, Combs's California civil team files the amended answer. The citizen's arrest theory? Gone. Replaced with a consent line. Actually, hold on. Back up. Because that's the part one want to sit with. You don't drop a citizen's arrest offense in 15 days because you got smarter. You drop it because somebody on the team looked at it and went, this hurts us somewhere else. And the only place that defense can hurt you, outside the 4 corners of Hayes' civil suit, is in a DA's office that's currently weighing whether to file criminal charges based on those exact same facts. Think about it. Citizen's arrest is an admission of restraint. Restraint plus the underlying sexual allegations is a much uglier story to hand a prosecutor than consent. The first defense narrates the encounter. The second one denies it ever happened the way Hay claims. That timing, 15 days after the appellate panel hints at relief on the federal case, is not a vibe. It's a recalibration. Look at the language itself, not the legalese, the engineering of the sentence. Plaintiff consented to any alleged false imprisonment which could have occurred, if at all, only while defendants were not present. That's 3 escape hatches stacked into one clause. Hatch 1, plaintiff consented. If the jury believes that, the false imprisonment claim dies. Hatch 2, which could have occurred if at all. This is the lawyer's hedge, denying that anything happened while still arguing about what would be true if it did. Hatch 3, only while defendants were not present. This is the geographical alibi. We weren't even in the room. Stack those 3, and what you're really saying is, he agreed to it. And if he didn't, we weren't there anyway. A defense lawyer's job is to keep options open. But 3 contradictory options inside one sentence isn't strategy. It's a flinch. It's a team that doesn't know which version of the story is going to survive contact with a prosecutor. Compare that to the consent or welcomed argument the same filing makes elsewhere, that Hay allegedly welcomed the conduct, that any physical contact was potentially self-defense against Hay's hostility, that Hay waited too long, that Hay failed to mitigate his own damages. That's not one defense. That's 7 defenses thrown at the wall on the off chance one of them sticks. And here's the thing about throwing 7 defenses at a wall. Prosecutors notice. Civil filings are public. The DA's office can read them. So can a grand jury eventually. And when your civil defense reads like a buffet of maybe this, maybe that, maybe nothing happened, maybe it happened but he liked it, you've handed the criminal side a giant credibility problem before they even open the case file. The bar Hayes allegations describe, the warehouse, the Biggie shirt, the R.I.P. Big line afterward, is detailed enough that it didn't happen is the only clean defense. Every fallback past that point starts to look like a negotiation. One more lens. Watch the verbs. Combs' civil attorney Jonathan Davis, last fall, was using language like categorically denies, false and defamatory, vindicate. The April 24th filing? Asked for comment. Combs' reps went silent. The volume dropped. That doesn't happen by accident either. Here's where it gets interesting, because depending on which outlet you read, this story is either nothing or everything. TMZ and the AOL write-up framed it as Combs drawing a hard line and aggressively pushing back against the lawsuit, leaning hard on the denial, on the demand to throw the case out, on the welcomed phrasing. Read that piece in isolation, and you'd think Combs' team is in command. They denied everything. They asked for judgment in their favor. Strong stance, right? The LA Times kept its eye somewhere completely different. The Times barely touched the amended answer. Their lens was the DA, the nearly 9 months it's taken to get to a charging decision, the careful note that prosecutors declined to say when the alleged incidents occurred or explain why the review is dragging. The Times is treating the civil filing as background noise and the DA review as the actual story. Deadline took a third lane entirely, pulling the Harvey Weinstein comparison out of the closet. Bicoastal justice. Felony versus misdemeanor sexual battery exposure. Several years in a California prison versus 6 months. Pardon hopes from Trump that have proved a bust so far. Deadline isn't covering a lawsuit. Deadline is sketching the outline of a second trial. So which read is right? Honestly, the counter-narrative, the Combs is winning. He denied everything. This lawsuit is going nowhere read. Sounds clean until you ask the obvious question. If you're winning, why did you just rewrite your strongest affirmative defense 15 days after your federal appeal looked promising? You don't do that when you're in command. You do it when you're triaging. And the pardon angle that some corners of the internet are still trying to keep alive, that one's been quietly buried. The reporting out of Deadline is that the Trump pardon route has not materialized. So scratch that exit ramp. Strip the spin. Line up the facts, and you get a different picture than any single outlet is painting. The civil filing isn't a flex. The DA review isn't a formality. And the silence from Combs's camp on the LA case, that's the part nobody's really sitting with. The PR is saying one thing. The paperwork is saying another. Always trust the paperwork. So let me give you the read you're not going to find in the legal trades or the gossip blogs. The popular take is that Combs's team is preparing a multi-front defense, and the amended answer is just routine lawyering. Sand the rough edges off the original filing. Tighten the language. Standard procedure. Try this on instead. What we're actually watching is exposure choreography. Combs's California civil lawyers aren't just defending one lawsuit. They're defending one lawsuit while standing inside the blast radius of a possible criminal indictment over the exact same alleged facts. Every word they put into the civil docket is admissible somewhere down the line. Every concession in the civil case becomes a brick the DA gets to use. Every theory of defense in the civil case becomes a theory the criminal prosecutor gets to anticipate, dismantle, or worse, quote back. That's why the citizen's arrest defense had to die. Because saying we restrained him legally in the civil docket is, in a prosecutor's hands, a confession of restraint. And once you've conceded restraint, the criminal case isn't fighting about whether something happened. It's fighting about what happened. That's a dramatically harder fight when the alleged victim is the only witness in the room and the physical setting, the Biggie warehouse, in 2020, is documented enough that the "we weren't there" defense gets harder to sell. So they pivoted. They moved from "we did it," and it was legal to "we weren't there," and even if we were, he wanted it. That's not refinement. That's a load-bearing wall being swapped out while the building is occupied. And there's a second layer. Allegedly, and I'm being careful with the word, Combs's team is also playing a clock game. The federal appeal is pending. The LADA review has been pending since January. Reports indicate the DA's office declined to explain the 9-month delay on a charging decision. The longer everything drags, the more leverage Combs's side has to clean up the civil narrative, settle quietly with anyone who'll take a check, and walk into a potential criminal proceeding with a sanitized paper trail. But here's where the strategy starts wobbling. The California sexual battery statute carries felony exposure of several years in state prison if Hochman's office goes that route. That's after Combs's existing federal sentence. That's after his appeal, which, even in the best-case scenario floated by his own lawyers, gets him out earlier, not all the way clean. And the existence of an active DA review, plus a sheriff's investigation, plus an LAPD investigation, plus a civil suit, plus the C.J. Wallace defamation countersuit. That's not the legal posture of someone whose lawyers are quietly winning. That's the posture of a team running 5 simultaneous fires with a garden hose. The popular framing has Combs's defense looking strategic. The paperwork has them looking improvisational. One of those reads is going to age really badly. I know which one I'm betting on. You want the cold version? Reportedly, the smartest thing Combs's legal team could do right now is shut up, settle the civil case quietly, and pray Hochman's office decides the proof problems aren't worth a public charging decision. Instead, they filed 7 affirmative defenses, including one that contradicts another one in the same document. That's not chess. That's a panic spreadsheet. Watch how this unfolds. By the back half of summer, expect the DA's office to telegraph its decision before it formally drops. Hochman's team has been sitting on these case files since January. That's the textbook window where prosecutors either start making courtroom-ready noise or quietly pass on a charging decision. If they pass, it leaks through soft channels first. If they file, the announcement will be coordinated, written for cameras, and timed to land while Combs is still locked in at Fort Dix. Watch for it. The cadence of the leaks will tell you everything before the press conference confirms it. The path that flips the table is Messier. Combs's legal team is about to find out that defending a civil case under the shadow of an active criminal review is genuinely the hardest thing a defense lawyer can do, because every move in one arena costs them in the other. Don't be shocked when more affirmative defenses get quietly amended, or when one of his California attorneys files a motion to withdraw. Anthony Rico already withdrew from the federal team before the NYC trial. Lawyers know when a case is structurally bleeding. The next withdrawal will tell you something the headlines won't. 5 years out. And this is the part nobody's tracking yet. The cultural residue of this whole moment isn't going to be about Combs the artist. It's going to be about how a generation of legal teams figured out, in real time, how to defend a high-profile civil case, while a parallel criminal review breathes down their neck. Combs's defense is the case study. The Weinstein parallels deadline is already drawing aren't accidental. Bi-coastal sex crime prosecutions are becoming a playbook, and Combs's team is currently writing one of the worst chapters of it in real time. And the Sun situation, Christian. We'll come back to that one in full, but the short version is, a young man with documented access to family resources who allegedly still hasn't locked in counsel is not a Tokyo vacation problem. It's a the well is dry problem. The unpaid attorney fees lawsuit that he and his father settled in February, over $53,000 in legal bills they didn't pay, wasn't a small story. It was the canary. Lawyers who don't get paid by the famous don't take the next call from the famous. That's how the legal economy actually works. By the time the next leaves change, expect at least one of these dominoes to land. Probably two. The bricks are stacked. The mortar's still drying. We'll be here. If you made it this far, you already know the move. Hit subscribe, ring the bell, drop your read in the comments. I want to know who's calling charges by August and who thinks this all dies on the vine. The next breakdown is already cooking. See you on the next one.